We continue now at the top of Daf Chof Meseches Shevuos. This is Shevuos Daf 25b. On the previous Amud, there was a machlokas amoraim between Rav and Shmuel. Let's say a person takes an oath, he takes a shvuah that so-and-so threw a pebble into the sea in the past tense. So Rav says a person is liable in such a case. Let's say that was not actually true. And Shmuel says the person is exempt. And the Gemara explained that the machlokas between them is that according to Rav, even though it's impossible to make that shvuah in future tense, a person cannot take a shvuah that another person is going to throw something into the sea because he doesn't have any control over that other person. But still, it doesn't have to be possible to make it in the future tense. The shvuah in the past tense is still considered a shvuah, and the person is liable. And Shmuel disagrees. Shmuel says no, the shvuah has to be able, at least in theory, to be made in the future tense, and therefore this is not a shvuah that is liable. That's why it's exempt. And the Gemara now says, let us suggest that this is actually the same machlokas that we find between the Rabbi Yehuda ben Beseira v'Rabbanan kamiflagi. They're arguing in the same machlokas as we find between Rabbi Yehuda ben Beseira and the Rabbanan. And Rashi explains, Rabbi Yehuda ben Beseira anishba l'kayim es hamitzvah polig v'lo anishba shelo l'kayim, talking about a situation where a person takes an oath to fulfill a mitzvah. That's what Rabbi Yehuda ben Beseira argues against the Rabbanan with regards to, but he does not argue with regards to saying that in the negative. Let's say a person takes a shvuah not to fulfill the mitzvah, as we will see in a moment. T'tanan, as we learned in a Mishnah coming up, nishba levatel es hamitzvah v'lo bitel. Let's say a person takes an oath that he wants to nullify a mitzvah, meaning to say he takes an oath against doing a mitzvah, violating the Torah, so that's not an oath. So Pater, he's exempt. And l'kayim es mitzvah, let's say the other way around. Let's say the person takes a shvuah, and the shvuah is in order to fulfill a mitzvah. He wants to take a shvuah about something that the Torah already says he has to do. V'lo kayim, and he doesn't fulfill it. Pater, he's also exempt, meaning according to the Rabbanan, both of these shvuos are not considered to be shvuos. Shahaya bedin sheyehei chayiv kedivrei Rabbi Yehuda ben Beseira. But according to Rabbi Yehuda ben Beseira, really there was an argument to be made that you should be chayiv in that second case of l'kayim es mitzvah. That's what Rashi meant when he said that Rabbi Yehuda ben Beseira argues specifically on l'kayim es mitzvah. To Yamar Rabbi Yehuda ben Beseira, because Rabbi Yehuda ben Beseira says that Rabbi Yehuda ben Beseira said, "Umayim horishus," if on something which is voluntary, she'eino mushba aleh mehar Sinai, where there's no oath, the person is not under oath from Har Sinai. It's not something that he has to do anyway according to the Torah. Hareyu chayev aleh, he's obligated, he's liable in that case when he makes a shvuah, meaning to say the shvuah takes effect. A shvuas bitoy takes effect on something which is a rishus. So mitzvah, something which is he has to do anyway. Shemush bo aleh mehar Sinai, he's under oath already from Har Sinai, he has to do it. Eino din sheyechayev aleh. Isn't it logical to suggest that if he makes a shvuah to do that thing, there's going to be a liability in terms of the shvuah as well? In other words, Rabbi Yehuda ben Beseira says that if a person makes a shvuah l'kayim es mitzvah, that is considered to be an effective shvuah, and the Rabbanan disagree. And Amru lo, they said to him, the Rabbanan said to Rabbi Yehuda ben Beseira, lo ima'amrit b'shvuas harashus. When we're talking about shvuas harashus, the reason why that's effective, shekain asa balav kahain, that's because the negative and the positive are both effective in that case. You can make it in the negative direction and you can make it in the positive. But Tomer b'shvuas mitzvah, but when it comes to a shvuas mitzvah, so there we understand that you want to make the shvuah in the positive sense, l'kayim es mitzvah, I'm going to fulfill the mitzvah, but you can't make it in the negative. Everybody agrees you're not allowed to make a shvuah to violate a mitzvah. Shekain lo asa balav kahain, over there, the negative is not the same as the positive, and that's why it's no good. And so essentially what's happening over here between the Rabbanan and Rabbi Yehuda ben Beseira is they're arguing whether a shvuah that you make, let's say, in the positive sense is only going to work if in theory it could be made in the negative sense. Very similar to the machlokas Rav and Shmuel. The machlokas Rav and Shmuel is whether a shvuah has to be able in theory to be made in the future tense. Rav says that's not necessary. Shmuel says it is. And over here the question is whether in theory it has to be able to be made in the negative sense. Rabbi Yehuda ben Beseira says that's not necessary, and the Rabbanan say it is. And so that's why the Gemara now says, Name a Rav Diomar Rabbi Yehuda ben Beseira. Let us say that Rav says like Rabbi Yehuda ben Beseira. Ushmuel Damar Rabbanan, and Shmuel says like the Rabbanan. And the Gemara says not necessarily, because again, the fact that it has to be in the negative and the positive is not necessarily the same as the fact that it has to be in future and in past. And the difference over here is that lahara o lahetiv, as we're going to say, that's explicit in the pasuk. That's lav v'hein. That's negative and positive. Whereas when it comes to future versus the past tense, that's not something that is explicit in the pasuk, as the Gemara now says. Alibud Rabbi Yehuda ben Beseira kuli alma lo pligi. First of all, according to Rabbi Yehuda ben Beseira, there is no machlokas, because hashta lav v'hein lo boy. If Rabbi Yehuda ben Beseira does not even require that it be in both the negative and the positive, and that's explicit in the pasuk, and yet he doesn't require it. Lahabo l'sha'avar, boy, do you think he's going to require that it has to be theoretically you can make it in the future for it to be valid if you make it in the past tense? Of course not. Ki pligi ali b'derabbanan. The whole machlokas between Rav and Shmuel is within the Rabbanan. Shmuel k'Rabbanan. Now Shmuel follows the Rabbanan. Shmuel says it has to be able, in theory, to be made in the future, and the Rabbanan, again, they're over here saying that it has to be, in theory, able to be made in both the negative and the positive. But Rav will respond to that and say no. Ki lo mechayvi Rabbanan belav v'hein. The Rabbanan, they only don't obligate the person by the negative and the positive. There they say it's necessary that it be able to be formulated in both the negative and positive sense. T'chsiv lohara o lahetiv behedya. Because in the pasuk it says for bad or for good, that's negative or positive. It says that explicitly in the pasuk, so that's a requirement that the Rabbanan have. Aval lehabo u'leshavar, but when it comes to in the future or in the past, d'mei ribuya dekroya, so that's just learned out from the inclusions of the pasuk. That's not learned out specifically from the words of the pasuk, so maybe that's not as necessary. Maybe mechayve, maybe they would say the person is liable, even though it's not theoretically possible to make this shvuah in the future tense. The person is still liable for that past tense shvuah. And the Gemara continues, Mesev Rav Hamnuna. Rav Hamnuna asks a question from a Mishnah coming up, and this is a question on Shmuel's opinion. Again, Shmuel says exempt in a situation where the Shavuot was made in the past tense, but it couldn't in theory be made in the future tense. The Mishnah coming up says, Lo achalti hayom v'lo hinachti tefillin hayom. Let's say a person says, I didn't eat today, or a person says, I didn't put on tefillin today, and then mashbiach ani, then someone says, can I put you under oath in terms of that? V'yomar amen, and the person says, amen. So chayiv, so the Mishnah says that the person is liable. Both of these shvuas, they do take effect. And the Gemara says, Bishlama lo achalti. Now I understand in the case where a person takes a shvuah that I did not eat, so isei below ochel, so that can in theory be made in the future tense. I will not eat, and so therefore that does not pose a problem for Shmuel. Ela lo hinachti, but if a person says I did not put on tefillin, so mi isei below aniach, is it possible to say I will not put on tefillin? That would be taking a shvuah to violate a mitzvah. You can't do that, and so therefore it cannot be done in the future tense. Shmuel would say if it can't be done in the future tense, the past tense also is not effective, and yet this Mishnah says the past tense is in fact effective, and therefore this is a question on Shmuel. And the Gemara says, "Who mosiv lo?" He asked the question, meaning Rav Hamnuna asked this question, "V'hu mefarik lo," and he answers the question as follows: Litzdadin katani. The way you have to learn this Mishnah is to sides, meaning to say it's talking about two separate points. Each line in the Mishnah is a separate point. Lo achalti, when it says I did not eat, so there we talk about a liability lekarbon. There we're talking about a liability for carbon. Shmuel's halacha that it has to be theoretically you can make the shvuah in the future tense is specifically talking about the liability to bring a carbon. So over there you're actually liable to a carbon because it's possible to make it in the future tense. But lo hinachti, but let's say the person didn't put on tefillin in the past tense, which is impossible to make that shvuah in the future tense, so that would only be lamalkus. That would only be a liability in terms of getting malkus. Let's say in such a situation the person was warned not to make this shvuah, he made this shvuah, and it turned out to be a false shvuah, so he's going to get malkus in that case. But in terms of bringing the carbon for shvuas bitoy, which is the carbanola v'yorei, that would not apply in this situation according to Shmuel again, because it's impossible to make this shvuah in the future tense. And the Gemara continues, Mesev Rava. Rava asks a question from the following Mishnah. This is also a Mishnah coming up. Ezu hi Shevuas shav. What's considered to be a Shevuas shav? That's an oath that's taken in vain. So that's nishba l'shanos as hayadua la'adam. That would be, for example, if a person takes an oath and he says something that everybody knows is not true. For example, v'yamar al amud shel even shu shel zav. He says about a pillar of stone that it's actually a pillar of gold. That would be an example of a Shevuas shav. That's what the Mishnah says. V'yamar ula, and ula says v'hu shenik legimel b'nei adam. When we say that it's known to be false, that which he is saying, and therefore it's a Shevuas shav, that's if at least three people know that what he's saying is not true. If three people know that this amud shel even is actually made out of stone, it's not made out of gold, so then it's something that's considered widely known, and if he makes that shvuah, he says something that's not true, that's going to be considered a Shevuas shav. And so the Gemara now says, Taima de nikr, the reason why it's considered a Shevuas shav is because it's known to everyone that what he's saying is not true. Hello nicker, but let's say it's not nicker, let's say it's something that's not so known, but again what he's saying is in fact not true. So over mishum Shevuas bitoy, so apparently that would be a transgression of a Shevuas bitoy. Let's say the person would say about an amud shel even, about a stone pillar, that it's actually gold, and this is not something that people were aware of, so that would be considered a Shevuas, what's called a Shevuas bitoy, which we are talking about. And why is that a question? The question is as follows, v'amai, but why should it be that this, according to Shmuel, why should this be a good Shevuas bitoy that actually takes effect. Ha'eno b'yehei shel zavu. Again, this cannot be made in the future tense. A person would not be able to make an oath that this should be gold. That wouldn't make any sense. And so therefore, again, you have that problem. Ha'eno b'yehei shel zavu. Again, it cannot be in the future tense that it should be gold. And so we have a question on Shmuel. And the Gemara says, Hu mosiv la v'hu mefarik la. Again, he asked the question. This is referring to Rava. Rava asked the question and Rava answered the question. Really, the way to understand the Mishnah is as follows. Nikr, that if it's something that everybody knows about, it's recognized over mishum Shevuos shav. So then again, the person transgresses, it's considered a Shevuos shav, as we said. But lo nikr, but in a situation of lo nikr, it's not actually a Shevuos bitoy, it's something else. It's in a different category. Over mishum Shevuos sheker, that would actually be called a Shevuos sheker. It would not fall in the category of Shevuos bitoy, because again, Shevuos bitoy has to be theoretically, you can make it in the future tense. That requirement does not apply to Shevuos sheker. That's why this will fall into the category of Shevuos sheker. And the Gemara continues, Amar Abaya, Abaya says, Umoda Rav. Now Rav would admit, again, Rav is the one that says that it doesn't need to, in theory, be able to be made in future tense in order to be considered a Shevuos bitoy, but Rav would admit, but Omer lechaveru, let's say a person says to his friend, Shvua sha'ani yodea l'cha edus, I'm taking an oath that I know testimony regarding your case. V'shtakach delo yada, it turns out that he did not actually know the testimony, so the Shvua was actually false. V'shtakach delo yada, it turns out that he doesn't know any testimony for him. So in that case, the pater, in that case, actually, he would be exempt. That Shavuot would not take effect. And why is that? Hoel v'lese bechlal she'eni yodei l'cha edus, because there it's impossible to take the Shavuot in the negative. Again, Rav was essentially would admit that a Shavuot has to theoretically be made in both the positive and the negative. And since it's not possible to make the Shavuot of eni yodei l'cha edus, that I don't know testimony, therefore, again, this Shavuot is not going to take effect. Rashi explains, Umoda Rav, diafa gav de lo boy lahabov v'l'sha'avar, even though Rav does not have a requirement that it's possible to make the Shavuot in both the future and past tense, lav v'hein boy, he does require that it be able to be made in the negative and the positive. Va'omer Shavua sha'ani yodea l'cha edus, person who says a shvua that I know edus for you, hein mashkachas ba, so you could do that in the positive, I know testimony. But lav lo mashkachas ba, it's not possible to do it in the negative. To lesse be'eni yodei lecha, a person can't say I don't know the testimony. De'eni yodei lecha edus lav mishum shvias bitoy chai ve'rachmana. The idea over here is that if a person takes a shvua that I don't know any testimony, that's not actually in the category of shvuas bitoy. That's called shvuas ha'edus. It's a different category listed in the pasuk. Le'eschayev b'chutz lebezin. Shvuas bitoy is something that you're chayev outside of bezdin. Shvuas ha'edus is specifically in bezdin. The halach is that would be in the category of shvuas ha'edus in bezdin, not outside of bezdin. Elamishum shvuas ha'edus. Again, that would be a shvuas ha'edus example, not shvuas bitoy. Ve'ena ela bebezdin u'v'roi l'hoyed. There are certain requirements by shvuas ha'edus. It has to be again in bezdin. It has to be by someone who is actually able to testify in this case. And so therefore, since Eini Yodea L'cha Edus is impossible in terms of Shvuas Bitoy, so also in a situation where he would say Yodea L'cha Edus, that also would not be considered a good Shvua. That's what Abai is explaining that Rav would say. And Abaya continues, Yodati velo yadati. What about a case where a person says in the past tense, I knew or I did not know? So that's a machlokas. That's going to be a machlokas between Rav and Shmuel. And Rashi explains for that, Yodati velo yadati machlokas. The Rav u'Shmuel. That's a machlokas, Rav and Shmuel. Again, Rav says a shvua takes place even though it cannot be stated in future tense. Shmuel says it has to be able to be stated in future tense, otherwise it's no good. So in this particular case, let's say a person says, I knew testimony in past tense, or I did not know. So di'ise belav v'hein. So that's a situation where you can do it in both the negative and the positive. I knew or I did not know. But v'lese belahaba. But you're not able to say that in the future. I will know testimony. That won't make sense. Or I will not know. The nishba levatel asamitzvah. Because there you're effectively getting involved, even in a situation where you're going to say I will or I will not testify. You're getting involved in levatel asamitzvah. A person knows testimony, so he's obligated to testify in such a situation. And the Gemara continues along the same lines. Hey, aditi velo hey aditi. Just like in a case where he says I knew testimony or I did not know in the past tense. Same thing if he says in the past tense I testified or I did not testify. Again, that's also a machlokas. That's also machlokas between Rav and Shmuel, because again, that's in the future tense. That's going to be problematic to say I will or I will not testify, because that's getting involved in levatel asa mitzvah. There are obligations to testify if a person knows the testimony. And so again, the idea in both of these cases is that, for example, in the case of Yadati, it's impossible for a person to say, I will know testimony. There's no way to know that. And in terms of testifying, if the person does know the testimony, there's an obligation to testify. So the person cannot be testifying about something that is a mitzvah. And that's why, again, it can't be stated in the future tense. So in the past tense, it's a machlokus between Rav and Shmuel. And so therefore the Gemara continues and says, Bishlama l'Shmuel, it makes sense according to Shmuel, because he says by Shavuos bitoi, if it cannot be done in the future tense, you're not going to be liable in the past tense. So lahachi afkar achmana l'Shavuos edus mechlal Shavuos bitoi. That's why the Torah has a separate category of Shavuos edus outside of Shavuos bitoi. Again, the idea is, what is Shavuos edus? Shavuos edus is a situation where a person takes a shvua that he does not know testimony. Now, according to Shmuel, you cannot take that shvua in the future tense. You can't say that you, in the future, are not going to know the testimony. That's not really possible. And so, therefore, it's not a Shavuos bitoi. That's why you need a new category called Shavuos edus over here for the person to be liable. But the Gemara continues and says, Ela l'Rav, but according to Rav, that it doesn't need to be possible in the future just to be liable in the past. L'mai hilchasa afkar achmona. Why is it that the Torah has a separate category of Shavuos edus? And when a person takes that shvua and says, I do not know testimony, why not just have that be a Shavuos bitoi? That would be something where if it's false, it's a Shavuos bitoi and is liable. Why did the Torah have to invent a new category called Shavuos edus according to Rav? And the Gemara continues and says, Amru Rabbanan Kame di Abaya. The Rabbanan said in front of Abaya that maybe the idea is very simple. L'chiyuve ala tarti. Maybe it's just an order that the person should be liable for two violations. In other words, you have a situation where a person makes such a shvua, he's going to be liable for both Shavuos bitoi and he'll be liable for Shavuos edus as well. And the Gemara says, Amar Lu, he said back to them, Abaya responded, it's not true. Tarti lo matziso amri, so you can't say that the person is liable for two. Titania, because we already learned in a brisa, la'achas me'ela, the pasuk says li'achas me'ela, and it's li'achas atam mechayvo, you're only going to make him liable for one, v'atam mechayvo shtayim, you're not going to make him liable for two, and therefore that is not going to be a good answer. And Rashi explains, Tarti tu, imroi lohoyedhu, v'kafar bo bebezin. Let's say, for example, the person is fit to testify, and this denial takes place in court. Those are the conditions for Shavuos edus. Chayev shtayim, he's liable too. Misham Shavuos edus, Misham Shavuos bitoi, he's liable for both Shavuos edus and Shavuos bitoi. And Abai says that's not a good answer because it says in the pasuk liachas, it says the word liachas, bahi in yona ksiv. That's written in the context in this discussion over there in the psukim. Ki yesham laachas me'ela, uses that word, that term, and so therefore again it means he's only chayev one and not chayev two. And so therefore again we are back to our question within Rav uli Abaya. According to what Abaya is saying, that you only chayiv one. Again, l'mai hilchasa afke rachmana. Why is it that the Torah has this separate category called Shavuos edus? According to Rav, aren't you already obligated anyhow because of Shavuos bitoi? And the Gemara answers to that, l'chidatanyas, for what we learned in the following brisa. Bekulon nemar v'nelam. By all of them, it says the word v'nelam, which means there was a lapse of awareness. V'kan lo nemar v'nelam. But over here, it's talking about Shavuos edus. It doesn't say the word v'nelam. It doesn't mention a lapse of awareness, l'chayev ala mezid keshogeg, and that's why a special category Shavuos edus, you're chayev b'mezid, you're chayev even if it's done on purpose, just like if it's done by mistake. And that means to say you're chayev the carbon ola v'yored by mezid, just like by shogeg. Rashi explains, Uli Abai l'may hilchasa aliba de Rav. This is all a question according to Rav within Abaya, because again Abaya says there's only one liability. Bekulan b'chol haksuvan b'carbon ola v'yored. All of the cases where it talks about carbon ola v'yored, and those are Shavuos bitoi v'tomas mikdash v'kadoshav nemar v'nelam. The two cases are Shavuos bitoi and tomas mikdash v'kadoshav. There's a carbon ola v'yored. Again, that's the sliding scale carbon chatas. Depending on how wealthy the person is, that's the kind of carbon that he brings. So it says the word v'nelam by Shavuos bitoi and tomas mikdash. But the third case of carbon ola v'yored, which is the case of Shavuos edus, v'kan v'Shavuos edus lo nemar v'nelam. It doesn't say v'nelam, and so therefore again the reason why it doesn't say v'nelam over there is because by Shavuos edus there's a chiyuv to bring the carbon ola v'yored even if it's done b'mezid. And the Gemara continues, Amrulei Rabbanan li Abaya. So the Rabbanan, they said to Abaya, Ema b'mezid mechayev chad. But why don't we say as follows? If it's done on purpose, then the person is going to be liable to just bring one offering. But b'shogeg, but if it happens by mistake, maybe mechayev tarti. Maybe there the person would actually be liable to bring two carbon ola v'yoreds. As Rashi explains, b'mezid the lesse l'Shavuos bitoi. Let's say it happens b'mezid, so then again, mezid only applies by Shavuos edus as we just said. So over there, mechayev chad misham edus. Ha'edus, you're going to bring one carbon because of Shavuos Ha'edus. But maybe we should say that b'shogeg, let's say the person does it by mistake, where already there's a possibility to be liable for Shavuos Bitoy as well. Mechayev Tarti, maybe the person is obligated to bring two carbonas, meaning the Rabbanan are saying to Abai, you said that you only bring one carbon. Maybe that's true specifically b'mezid, because when it's done b'mezid, you only have Shavuos Ha'edus. But if it would be done b'shogeg, maybe there should be two liabilities in terms of carbonos. And to that, Omar Louis said to them, Lav hainu de'amri, no, that's what I was saying. La'achas, achas atamechayvo, vi atamechayvo shtayim. Again, the pasuk says li'achas, which means he only brings one and not two. V'i b'mezid. Now, if the pasuk, when it said li'achas, was talking about a scenario of b'mezid, so mi'ikatarti, there wouldn't even be a possibility of bringing two. The pasuk wouldn't even need to say it, because b'mezid only applies by Shavuos Ha'edus. So the fact that the pasuk is going out of its way to say you bring one carbon and not two, that must be in a scenario specifically of shogeg that the pasuk is saying that. Rashi explains, Lav hainu di'amri l'chu, that's what I was saying to you. To v'hed yamiate kra, that the pasuk is saying that it's excluded milachayve tarti, that he's not chayiv too. V'al karchach b'shogeg hu d'miate kra, it has to be the pasuk is talking b'shogeg, to ibn mezid, because by the case of mezid, mi'ika tarti, there isn't even a possibility of two. V'lamali l'mu'ute, why would I need to exclude it? Ha'en chiyav b'itoy b'mezid, there is no chiyav for Shavuos b'itoy in a situation of b'mezid. And the Gemara continues, Rava Amar Rava says, Mishum dahav davar shebechlal. The real reason why when it comes to Shavuos Ha'edus you bring one carbon and not two, it's not because of the pasuk that says liachas, it's because this was something that was included within Shavuos b'itoy. This case really should have been included. V'yotza lidon b'davar hachadash, and then comes along the pasuk and gives you a novel idea in terms of Shavuos Ha'edus, and the rule is ein l'chabo el chidusho bilvad. The rule is that you can only apply the chiddush, that novel idea, and nothing beyond that. Rashi explains, Rava Amar Rava says, Kolomar lo tzorech l'mu'utei milachas. Rava is saying you don't need to exclude the idea of bringing two carbonas from the word liachas. V'chiyasa la'achas l'mu'utei mechiyav shtayim. When the word liachas is excluding two liabilities, lav la'edus ubitoy also. That's not an exclusion in the case of a Shavuos Ha'edus, which is also a Shavuos bitoy. Ela lebitoy lechudei. That's actually in the context of just a Shavuos bitoy, meaning shemamar Shavuos shelo ochel. Let's say a person takes an oath, he's not going to eat. V'yachal paschitin upas saor upas kusman, and then he eats wheat bread and barley bread and spelt bread. Eino chayiv la'achas. So there the pasuk is saying la'achas. It's saying again you're only chayiv one. Aval edus ubitoy. But let's say you have a situation where the person takes a shvuah which falls in the category of both Shavuos Ha'edus and Shavuos bitoy. Lo tzarich miyuta. You actually don't even need an exclusion to have a edus davar shaya bechlal, because Shavuos Ha'edus is something which was bechlal bitoy. It was included in Shavuos bitoy. V'yotza b'fnei atzma. But then it was created its own category. Lidon b'davar hachadish, that it's a novel new category, that it only takes place when it's somebody who's able to testify, and it takes place only in court, and therefore ein lach bo ela chidusho, you can only apply the novel idea in such a case. Umisham edus chayiv, and he's going to be chayiv because of Shavuos Ha'edus, v'lo misham bitoy, but not because of bitoy. That's Rava's understanding. That's why again there's a liability only for Shavuos Ha'edus, because it's considered to be a davar hachadash. It's yotza lidon b'davar hachadash, and ein lach bo ela chidusho. But the Gemara continues and says, Mechlal, but that would imply the Abaya Savar, that Abaya holds Isa l'Shvuah B'Olam, that the Shavuos Bitoy does exist in theory, meaning Rava is saying that in a situation of Shavuos Ha'edus, there is no Shavuos Bitoy whatsoever. It's essentially Ein L'Chabo El Chidusho. But according to Abaya, it's just an exclusion that you can't be liable to. But let's say you had a situation where there was only one liability anyhow, you could be liable for Shavuos Bitoy. As Rashi explains, Mechlal di Abaya di Itzrich Krolam Ute. This implies that Abaya, who needs that pasuk of la'achas to say that you're only bringing one, Savar Isa l'shvuah b'olam, he holds that the shvuah does exist as a shvuas bitoy. Kilomar Isa l'shem shvuas bitoy, meaning it is called a shvuas bitoy, be'eni yodei l'cha'edus. When a person says, I don't know testimony about this case, according to Abaya, that is referred to both as shvuas ha'edus and shvuas bitoy. V'haidelo mechayev tarti, the only reason you're not chayev to karbonos is mishum miyutas, because of the exclusion. De'enatam mechayev oshtayim, because you're not able to be mechayev in two karbonos. That's the reason. V'nafkamina, so the difference between Abai and Rava would be, heicha di'isa lebitoy v'lesa le'edus. Let's say you'd have a scenario where Shavuos bitoy applies and not Shavuos ha'edus, could go in bipsulin le'edus. For example, let's say people who weren't able to testify, they're disqualified from testimony, so therefore the Shavuos ha'edus doesn't apply. O shelo bebezin, or let's say it's outside of the court. Deleka lemiftrei mila'achas. So there, you're not able to exclude them. You're not able to say that they're pater mila'achas mechayim mishum bitoy. There is no chiyuv because of Shavuos ha'edus, and so therefore therefore the pasuk of la'achas wouldn't apply to say that you're not chayiv because of Shavuos Bitoy, because you can't be chayiv too, because there's no chayiv for Shavuos Eidos anyway in such a scenario. So there, according to Abaye, apparently there actually would be a liability for Shavuos Bitoy, even though it's technically in the category of Shavuos Eidos. And in Rava's view, we would say ein lecha bo el chidusho. You can only make him liable for Shavuos Eidos and nothing else. But Abaye would say, as long as it's not excluded from achas, there would be a liability for Shavuos Bitoy over here. But the Gemara continues and asks, how can that be? V'amar Abaye, but Abaye said before, we just quoted earlier, that Moda Rav, that Rav would admit. But Omer l'chaver, if a person says to his friend, Shvua sha'ani yodea lecha edus, he says, he takes an oath that I do know testimony for you. V'eshtakach delo yadalein, it turns out that he actually did not know. So over there, the question is whether that Shvua takes effect or not. So Rav would admit to Potter, Rav would admit that the person is exempt, that the Shvua does not take effect. Hoel v'lese be'eni yodea lecha edus, because there, it's impossible to take the Shvua in the negative of I don't know the testimony. That's not possible, because again, if you say I don't know the testimony, there the obligation is only because of Shavuos Eidos and not because of Shavuos Bitoy. That's what Abaye was saying before, but now we're really saying within Abaye that there actually is an obligation because of Shavuos Bitoy. It's just that you cannot be obligated twice. But as long as we take away the issue of being obligated twice, apparently it is a Shavuos Bitoy. So what did Abaye even mean when he said that Rav would admit that Shvua sh'ani yodea lecha eidos is not a Shvua because it doesn't apply in the negative as a Shavuos Bitoy? In fact, it does apply in the negative as a Shavuos Bitoy. As Rashi explains, V'amar Abaye le'el, Abaye said earlier, Delese l'shem Shavuos Bitoy, b'Shavuos Eidos. It's not even called a Shavuos Bitoy if it's in the category of Shavuos Eidos. V'yemisa harayeshna be'eni yodea lecha eidos b'psulin shelo b'bezin. But if it's true what we just said, so really it is considered a Shavuos Bitoy. Again, let's say, for example, a person would say, I don't know any testimony, and we're talking about people that are either disqualified from testifying or this happens outside of the court, it would be considered a Shavuos Bitoy. So that's the opposite of what we said before. And the Gemara says to that, Hadr be Abaye me'ahi. Actually, Abaye retracted from that. In other words, that earlier statement where Abaye said that Rav would admit in a situation of Shvua sha'ani yodea lecha eidos that would not be a Shvua because it does not apply in the negative, Abaye actually retracted from that. In fact, it does apply in the negative. And the Gemara continues, V'yibayisem, if you want, I could say, and we will continue with this discussion in the next video on Daf Chavav Amud Aleph.